Okay, can y'all hear me now?
Yeah, we got you.
Okay.
All right. Welcome to an oral argument session of the Fifth District Court of Appeal. This case was initially set for oral argument in April. However, we got caught up in the pandemic and had to cancel it. And I appreciate the parties and the other members of the panel cooperating to get this rescheduled as quickly as we could for oral argument. This is the case of Goings versus Praetorian Insurance Company, 1835-46. I am Judge Cohn from Orange County. We've got also a member of the panel, Judge Wallace from Orange County, and appearing at least now telephonically, Judge Edwards from Seminole County, where the internet isn't as good as it is in Orange County. Both sides will be entitled to up to 20 minutes each for their argument. If the appellant would like to reserve we do a standard of 5 minutes for rebuttal, but you're free to reserve whatever time that you would like. We are recording this, so all right, we've got a live sighting of Judge Edwards now. So, all right, I've delayed it long enough that we were able to accomplish that. And so, and I know I'll probably mispronounce it, but is it Giassi?
Giassi, Your Honor, hard G.
Well, I predicted I would do that. Ms. Giassi, you may proceed.
Thank you very much, Your Honors. May it please the court? I will just take the standard 5 minutes for a rebuttal.
Very good.
My name is Melissa Giassi with Giassi Law, and I represent the appellant, Mrs. Pamela Goings. Your Honors, at its core, this appeal is about whether a homeowner has standing to enforce a forced place policy purchased by that homeowner's lender. Before
let me start. Go ahead. I'm sorry.
No.
Go ahead. I was going to start with an argument made in your brief calling Praetorian's position ludicrous. Now, do you know how many judges in total have accepted their position, including middle district judges and appellate court judges?
Actually, Your Honor, there's no middle court district that has accepted it. There's a split.
That was my question. My question was how many federal court, if I said middle, I meant how many federal court district judges and how many appellate court judges in the state have accepted that position?
I'm aware of one Southern District Court case involving Praetorian specifically. If you're talking about forced placed policies in general, yes, I will concede that there have been some Southern District rulings.
I'm just suggesting that your use of the word ludicrous is a little strong in terms in the
maybe
sense
it was over passionate on my part, Your Honor. So maybe I should have said something a little less powerful.
Unprevailing, perhaps.
Unprevailing, something. Okay. I'll concede that.
All right, go ahead.
Thank you, Your Honor. Again, obviously the court's aware of what this case is about at its core, and it's about whether my client who pays for this policy lives in the house and is financially obligated for the policy has the standing to enforce it. And there is no binding precedent, Your Honors. This is, for all intents and purposes, a case of first impression before this court. The only other district court opinion that touches on this issue, but really certainly doesn't provide any sort of precedent or it has no facts in the opinion, was the Wreath Jean-Louis case that was filed as supplemental authority by my opponent.
Yeah. Now let me ask this: doesn't the to be considered a third-party beneficiary, doesn't the language of the contract have to clearly manifest an intent to benefit a third party?
Yes, Your Honor, it does. But I question whether the language here, I think there's two questions before this court. Does it? The language in this policy I would submit leaves open room for interpretation whether or not there is a benefit to Mrs. Goings. And we, explored that analysis in our brief. It certainly does not, like the Middle District has come to a conclusion, it does not specifically or expressly state that there's no intention for there not to be benefits for Ms. Goins. And I think that's essentially the split between the Middle District of Florida and the Southern District. The Middle District has said that in order for there not to be third-party beneficiary standing, the contract of insurance, the forced place contract, has to expressly state that there's no intention for the contract to benefit the homeowner. And that language is not present in this policy, Your Honors. There's certainly forced place policies out there that have that language, but it's not here. And so, looking at the language of this policy, and we've, outlined it in our brief, it's at best ambiguous. There are places in the policy where it provides direct rights to Mrs. Goins. She, in addition to the lost payee clause, there's the provision where the policy, even on the declaration page, it states it may not sufficiently protect borrower's interest in the property. So you have that example right there. Going on to some of the additional coverages on page 24 of the record, there's, two interesting paragraphs, and, these cases are all about the language in the policy. That's something I'm sure this court is very familiar with. We have paragraph 2 dealing with debris removal, and the language says we will pay your reasonable expenses, which is, a reference to Midland. But the next paragraph says, in the event of a loss, we will pay the reasonable cost incurred for necessary repairs that are made solely to protect the residential property. And
Counsel, the language Judge Cohen referred to earlier, in order to be a third-party beneficiary, the contract has to identify a specific intent to primarily and directly benefit Ms. Goins, and this contract doesn't really seem to do that at all. I mean, there may be indirect benefits, there may be collateral benefits and all the rest of that, but I mean, as a strict third-party beneficiary, you come up a little bit short, don't you, on that test?
Respectfully, I disagree, Your Honor, and even the third district opinion cited to this court's precedent in the Dingle case, and that case says that the intended beneficiary does not even need to be named in the contract. And it says that the court is perfectly capable of looking at the parties' pre-contract actions and intentions and the post, the actions of the parties after the contract to, look at the intent of the parties. So what do we have here prior to the entry of the policy or at the inception of the policy? We have a notice from one of the parties to the policy, Midland, to the named insured. It's on page 14 of the record. It doesn't state anything it does not inform Mrs. Goins that she has no benefits under this policy. It simply states that the policy will provide less coverage than your own policy. On the second page of that same notice, it advises her that there's not coverage for certain things that might be, provided for in a typical homeowner's policy, such as medical payments, loss of wages, or additional living expenses. And then it goes on to say this insurance covers only compensation up to policy limits that are above and beyond any existing insurance in effect at the time of loss. In short, the notice from Midland it's indicative of Midland's intent for this policy to benefit Mrs. Goins. And the brief.
Ask you this: how does Florida Statute 627-405 have any interplay with the third-party beneficiary? Does she need to prove that she's a third-party beneficiary given 627-405?
No, she doesn't have to necessarily. I think our argument as to that statute, Your Honor, is that she very clearly has an insurable interest under Florida law. And obviously that statute was enacted to prevent individuals or companies that don't have, an ownership interest in property from purchasing insurance and benefiting from, any benefits paid as a result. But, to the contrary, and we argued in the brief that to the extent the contract of insurance attempts to contract away, the statutory insurable interest granted by that statute, it goes against public policy and it can't be enforced. So I think that's.
When did you make that public policy argument below? Can you cite where in the record that argument was made below?
Well, and I understand that preservation was raised in the answer brief, Your Honor, and our response to that is we raised the argument that 627.405 provided, standing as an insurable interest. So, to the exact words public policy were not used, but I would submit that.
Where are the indirect words used? Where is there any even hint of that argument raised below?
I believe it was raised, the argument that the insurable interest statute gave standing was raised in the motion for rehearing.
No, I'm not talking about the standing. I'm talking about the public policy argument.
Well, I mean
maybe standing and public policy are two very different concepts.
Sure. Okay. And maybe it's not, maybe I'm mislabeling it a public policy argument, but essentially the statute gives the, Mrs. Goins standing and through her insurable interest. So to the extent that, the contract removes that, that's the argument that we're relying on.
Okay.
Does that answer the court's question?
Yeah, I'm taking the answer is it wasn't raised below. That the argument as to public policy was not brought before the trial court. Okay, well,
but what I'm trying to explain is the label of the argument wasn't made, but the argument most certainly was raised in rehearing, and I believe in the memorandum in opposition that the statute gave the insured standing because she had an insurable interest.
A lot of the cases that deal with that type of standing say the homeowner is enforcing the rights of the mortgagee, and here appellee certainly has taken the position that you're not trying to enforce the rights of the mortgagee, you're only trying to enforce the rights of the owner under the policy, and there are none.
And I understand that was an argument raised in the answer brief, and our response to that argument is, she's seeking to enforce the policy because she owns the property. She's seeking an award of money of damages, and they state that we're trying to derogate some sort of right on the part of Midland, to its rights under the policy. But frankly, the only summary judgment evidence before this court was the policy. So I think that argument is not supported by the record. And second, there's no dispute that there was an underpayment and there was a breach. And so this lawsuit is proceeding just like any other first party lawsuit would. There's a breach of policy, and it's an industry standard, Your Honors, that when there's benefits paid under a policy, if there's a mortgage company, their name is on the check. So, I don't think that, any attempt whatsoever for us to circumvent the rights of Midland. And that's not, the intent. And to the extent that Midland's not enforcing its rights under the policy, which again, the only summary judgment evidence that we had was the policy, but, Midland's and Mrs. Goins' interests are aligned 100%, to the extent that, Midland procured this policy to secure its security interests. It wants the property to be repaired. It wants the property to maintain its value. And we can't ignore the plain fact that, Mrs. Goins is financially liable for the policy premium. So, when you look at the Dingle case and you look at the fact that it's not necessarily required for the party to be named in the contract, and you can look at the pre and post contract intention of the parties to look at, who they expected this to benefit. And, peeling back a few more layers, Midland purchased this policy. You have to look at the intent of it. It purchased the policy to protect its security interests in the property. So regardless,
Midland didn't seem overly concerned about trying to make some sort of claim.
There's more mortgage service companies never are, and that's that's part of the reason why homeowners like Mrs. Goins are forced to assert their rights. I don't know why Midland wasn't concerned. I don't know how to make them concerned, but I think
In the Rand Investments versus Indiana Insurance Company, there the owner joined the lender in the case, I believe. Here you chose not to join the lender in the case. Doesn't that show that you're pursuing the owner's rights and not the mortgagee's rights?
I think the owner, the borrower's rights and the lender's rights are one and the same. So, I think that circles back to what happens when benefits are paid under the policy. The check, either it's jointly payable to both the insured and the mortgagee. And, I see I'm getting.
Under this particular policy, there's no payment made to the owner unless the payment exceeds the lender's insurable interest. Isn't that correct?
There's no payment made directly to the owner, no, Your Honor, but there would be
Where does it say anywhere in the policy that they would issue a check to both the owner and the mortgage company unless the mortgage company's interest had been exceeded, or at least there was a question about it?
It doesn't say that, but my point and what I was attempting to, I think, clarify when I said that was, Mrs. Goins is not attempting to, subrogate any rights of Midland. Maybe if this went to trial and there was standing, maybe the check would be payable under the terms of the policy. I mean, I think that that's, well within the insurance company or Praetorian's right to address at a later date. But, I don't think that precludes standing. Here we are at the very beginning of a lawsuit, and, Mrs. Goins is being prevented from asserting her rights. There's nothing in the record that shows, Midland's refusing to do it, but she's being prevented from advocating for rights that I submit are directly aligned with Midland Mortgage. If she procures money and it gets sent to Midland, it either reduces the principal that she owes on her mortgage, or Midland works with her to repair the property. And then I see that I hit my rebuttal time. But, on the question of intent, I discussed the fact, that Midland purchased the property, for it to protect the house owned by Mrs. Goins. And if you look at Praetorian's intent, it sold the policy and it promised to repair the property or pay Midland damages. And that is, again, intent 100% aligned to benefit Mrs. Goins. So I'd like to save the rest of my time for rebuttal.
Very good. All right. Thank you. All right. Mr. Young.
Good morning. My name is Scott Young. I have the pleasure of representing the Applee Praetorian Insurance Company in this case. Your Honors, this case is plainly about contractual interpretation and the interpretation of the contract between the parties, and the parties here are Midland and Praetorian, not the plaintiff.
Did Praetorian offer a payment?
Praetorian did make payments when the claim was asserted, and those payments were made directly to Midland. That's not in the record, but that's in fact what was that's what happened. Payments were made and they were made to Midland under the terms of the policy.
Why would Mrs. Goins have standing under 627-405?
627-405 is not a statute that grants standing. It's a statute that limits people who are parties to insurance contracts to recover under contracts when they have an insurable interest. And the Norfolk case originally stated that it's a statute of omission, and it is intended to limit rights rather than grant rights. Now, those two cases I would submit, are aberrations. Norfolk and the and the other case, which is escaping the tip of my tongue. I think those cases are aberrations, and while they did form the basis of the arguments of the rulings of the Middle District of Florida, I don't think that they should be considered by this court is governing anymore, and that's for two reasons. First of all, those cases, as were pointed out by the court, involved a situation where the party who's filing the lawsuit was a party to the contract, and they were seeking to enforce the rights of the mortgagee, which were set forth in the contract. That's not what's going on here. It is, the court noted, and is set forth in the complaint, which is contained in the record. There's nowhere where Mrs. Goins is seeking to enforce and request that Praetorian pay anything to Midland. On the contrary, if they had wanted to do that, then she would certainly have a better argument for standing, although I submit she wouldn't have it. But in both the Schubler and the Rand Investments cases, the court glossed over the general proposition that you have to look to the contract itself to determine whether there's a third-party beneficiary, and said that under these unique circumstances, because they were seeking to have the insurance company pay the mortgagee, then they wouldn't find standing in those cases. Now,
so here, if plaintiff here, the homeowner, had sued to enforce Midland's rights, Midland decides, say it doesn't even make a claim, or they get a lowball offer, which I'm sure is what Ms. Goins is saying, since I think the insurance company said the damages were in the couple of $1,000 range, and her folks said they were more than 20,000. Midland seemed fine with that answer. Doesn't she have the right to enforce the policy on behalf of Midland to have the repairs made at the actual value they are?
No, she does not, and that's the whole principle of third-party beneficiary contract interpretation. And while the Rand Investments case and the Schubler cases suggest that the plaintiff can seek to have the insurance company pay the mortgagee, I would submit that the Schubler and Rand investment cases are no longer good law, and that's based upon the Florida Supreme Court's decision in the Foundation Health case versus Westside EKG Hospital. The courts in the Schubler and the Rand investments didn't analyze third-party beneficiary standing by reference to the contract itself. And the Supreme Court's decision in Foundation Health, which was in 2006, many years after both of those cases, sets forth the clear test that's supposed to be applied in a situation where courts are interpreting and determining whether there's third-party beneficiary status in an insurance contract, because the Foundation Health case involved an insurance contract, and it set forth the four-part test. And part two of that test is there must be the clear and manifest intent of the contracting parties that the contract primarily and directly benefit the third party. In Schubler and in Rand Investments, there was no analysis of the language of the contracts. And so there's no way to look at those cases and find that they would comport to the Foundation Health case in any respect. But we know the Florida Supreme Court has said that you have to look to the contract, to see what the clear and manifest intent of the contracting parties is. And here, when we do that and look at the contract, it's clear that Ms. Goins has no rights whatsoever under the policy. The reliance on
not quite right. She does if it exceeds your insurable interest.
If she does.
The Midland's insurable interest.
That's correct. And there are lots of cases involving the same law firms where we litigate this case, and in some cases, those claims are made. Those claims are not made as third-party beneficiary cases. They're made as payees, because they're entitled to first-party benefits under the loss payment provision in that circumstance. But the policy clearly states that that's the only circumstance where a homeowner has rights under the policy. In fact, the policy itself makes it clear. This contract, and I'm looking at record page 20, which is part of the policy. It says the contract of insurance is only between the named insured and Praetorian Insurance Company. There is no contract of insurance between Barra and Praetorian Insurance Company. And it goes on. It's about as clear and unambiguous as it could be that Ms. Goins has no rights except for the extent that the damages exceed the interest of Midland in this case.
So she has an obligation to pay, but has no rights. That's your position?
I don't think that's right at all, because the obligation to pay, as between Praetorian and Midland, the obligation to pay is on Midland. It's not on Ms. Goins. And because, frankly, Praetorian is not a party to the mortgage agreement between Ms. Goins and her mortgage company. And so what happens between those two entities is really not relevant this. But to the extent that equity matters in all this, all Ms. Goins had to do was to comply with the contract that she had with her mortgage company and get insurance. So from an equitable standpoint, it's wrong to suggest that Praetorian is the bad guy here and not paying benefits that are otherwise due, that's not an accurate way to look at this case. Ms. Goins had the right to buy insurance. She was obligated to buy insurance under the terms of her mortgage. She didn't do it. And so she shouldn't be able to insert herself in a contract between Praetorian and Midland when that contract, which was negotiated between those two entities, specifically says she has no rights under the policy. She shouldn't be able to cite to a Florida statute, which is not applicable, because the fact whether or not she has an insurable interest isn't relevant. It's whether she is an intended beneficiary under the policy.
If there's a covered loss at the residence, isn't Praetorian obligated to pay the fair price for repairs under the policy to somebody?
Well, it's entitled, it's obligated to pay, replacement value or whatever that value is as dictated under the terms of the policy.
Exactly. And are they entitled to not have to pay that just because Midland doesn't care and doesn't want to make a claim?
Well, so yes, they did pay it in this case, and they paid it to Midland as they were required to do. And Midland didn't take exception, and it has done nothing further. And again, if the plaintiff wants to try to invoke any rights under the RAND investments case or those two cases where third-party beneficiary standing was granted, then she could have, number one, involved Midland, or number two, have pled and filed a lawsuit in which she's seeking to compel Praetorian to pay money to the mortgagee. And that's not what she did here, because that's not what she wants. She wants money and she wants attorney's fees. So yes, is there an obligation for Praetorian to pay when there's damage? Yes, there is. Is there an obligation for Praetorian to adjust the loss, to send an adjuster out there to investigate damage? Yes, there is. Praetorian complied with those obligations under the contract, and to the extent that it didn't, it's Midland is the party who has the right to complain, not the plaintiff.
Any further questions?
I'll conclude. I'm sorry.
Okay.
I'll say I'll conclude, because the cases that we've cited in our brief overwhelmingly support the proposition that the plaintiff here has no third-party beneficiary standing. All of the cases in the Southern District of Florida hold that. We recently submitted to the court an opinion from the Northern District of Florida and support that. We have numerous district court cases, which certainly aren't binding, but they are persuasive. We've had two rulings from Florida District Courts of Appeal. One of them is the Benny Robinson versus Universal Property and Casualty and Balboa case, which is a PCA affirmance of this exact issue. And that's 190 Southern 3rd 646. Again, that's a PCA with no comment.
But that has no persuasive authority.
Sure. And then there's the recent decision of the Wreath John Louis versus Praetorian Insurance Company, which is a third DCA case, which again is a per curiam, but a short opinion when it was issued. And that court, as we request the court to do here, is to look to the language, follow what the Supreme Court says, and for third-party beneficiary status, make the determination as to whether the contract between the parties is intended to primarily benefit Ms. Goings. Here, there's only one conclusion, that insurance policy is not intended by Midland and Praetorian to primarily benefit Ms. Goings. That was the ruling of the court. Look to the contract, and when it does not support that the conclusion that Ms. Goings was the primary beneficiary, that she is found to have no standing as a third-party beneficiary. And consequently, I would ask that the court join the 4th and 3rd DCAs and affirm this opinion and respectfully write a ruling addressing these issues so that there's some consistency in the appellate courts and the district court and the circuit courts going forward. So unless there are any questions, I'll conclude my arguments at this time.
Okay. Thank you, Mr. Young.
Thank you.
All right, Mr. Yasi.
Thank you very much, Your Honor. I want to go back to the intent. Again, the dispute here as to whether or not Ms. Goins could have standing as a third-party beneficiary is whether the contract primarily and directly, or the parties intended the contract to primarily and directly benefit her. You know, there's language throughout the policy, and that is highlighted in our briefs, and I provided some of the record sites earlier, where, you know, this policy has some ambiguities as to that intent alone. There are places in the policy, namely the reasonable repairs, where it provides for Ms. Goins to make a claim directly for any costs that she incurred. You know, there's statements throughout the policy that leave room for interpretation what exactly benefits, you know, she could claim directly. But, you know, as a third-party beneficiary, going back to this court's case of Dingle, which was cited by the 3rd District, you know, I just don't think that you can get away from the fact that the actions of the parties before, during, and after this relationship, they undisputedly form an intent that this policy and Mrs. Goins is a direct and primary beneficiary of it. Her interests are 100% aligned with Midland Mortgage, and I outlined that in my brief. You know, Midland wants the property to stay in good repair. Midland, you know, wants the value of its security, you know, not to depreciate. You know, that's exactly what Mrs. Goins wants. So, you know, Midland purchasing this policy, you know, whether or not it, you know, directly intended to, I mean, there's some inferences there that regardless of, you know, its intent, you know, by purchasing the policy, you know, it intended for Mrs. Goins to, you know, bear the benefit of this. I discussed how this is, you know, most likely homeowners, you know, their home is their primary asset. And, you know, there's no situation under this policy where a benefit is paid where it doesn't primarily and directly benefit Mrs. Goins. It's either paying to repair her property, or it's either going directly to Midland and it's reducing the balance that she owes on her mortgage. And again, going back to, you know, Praetorian's intent, you know, its intent when it issued this policy was to promise to repair the property or pay Midland for damages. And I just don't think that we can get away from, you know, the common sense aspect of the fact that, you know, this policy 100% benefits, any benefit paid under this policy, you know, benefits Mrs. Goins. And I'd like to, my opponent said that the contract specifically says that Mrs. Goins does not have any rights under that, and under the policy. I respectfully disagree, and those instances are identified in the brief. Not only does she have rights, direct rights under the policy, she has obligations. You know, some of Praetorian's actions following the submission of the claim, you know, they responded when she submitted the claim, they responded when she submitted the supplemental claim. You know, all of these actions can be considered by this court when you look at whether or not, you know, Mrs. Goins could qualify as a third-party beneficiary. You know, going back to Dingle, you know, that case involved an estate planning, a will that was drafted, and it ultimately was unenforceable. And this court allowed the plaintiffs to sue the attorney who made the will unenforceable. So, you know, there's all kinds of scenarios where a third party, it's appropriate for a third party beneficiary to have standing. You know, there's no question that there was, you know, those plaintiffs in Dingle were not named in the contract between the attorney and the client who wanted to transfer the property and his will. And, you know, again, just like Mrs. Goins, there's no question that, you know, but for the attorney's mistake in that situation, you know, they lost out on a benefit. So again, you know, the only result from this contract, any benefits paid under this contract are, you know, primarily and directly, they benefit Ms. Goins, and I would submit more so than Midland, who's a huge mortgage servicing company. I also, like my opponent, I believe very strongly that this case there needs to be some guidance for the trial courts, and I would respectfully ask the court to reverse the summary judgment, and write an opinion explaining why Mrs. Goins has standing as a third-party beneficiary to enforce the contract that she pays for. Thank you very much.
Yeah, but you understand that you know the contract, you know, what we're looking at in Dingle and the contract in this case are really apples and oranges.
The contract wasn't. I mean, I disagree. The contract between the attorney and the client didn't name the Dingles as within it, you know, but they were still allowed to enforce it as third-party beneficiaries. I mean, to that extent, I think it very closely parallels the situation here. So.
Okay. All right. Well, thank you both for your argument, and we'll be in recess.
Thank you very much, Your Honors.
Thank you.
Thank you.